Hi, I'm Emily and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's law office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, what is informed consent? When is my consent as a parent or guardian required?
Informed consent means that as a parent, you must be given full and complete disclosure of all relevant facts and information pertaining to your child regarding certain proposed activities by your local education agency. Consent remains voluntary and may be withheld or withdrawn at any time as it pertains to an initial evaluation of your child for special education services. Written parental consent directed to your child's school district is required when your child undergoes an initial evaluation to determine his or her eligibility for special education and related services. Informed consent is also required before your child is placed in special education services. Also, it's required before your child is placed in private placement and before your child is reevaluated for special education and related services. However, a parent's failure to give consent to a reevaluation of your child may be overridden if the school district can show that a good faith effort was made to obtain consent and the child's parent failed to respond. Consent to an initial evaluation must be in writing and may only be given following full disclosure of all information needed for you to make a knowledgeable decision pertaining to your child's educational needs. This written consent does not carry over and constitute consent in placing your child into special education. Separate written consent is required following an initial evaluation if your child is found to be eligible for special education related services. If a parent disagrees with a proposed special education activity, the school district must still ensure that your child receives a free, appropriate public education, also known as FAPE. However, if you refuse to give written consent for the school district to conduct either an initial evaluation or a re-evaluation, the school district may proceed on its own and initiate a due process hearing in order to move forward with the recommended evaluations of your child. On the other hand, if a parent refuses to provide consent for their child to be entered into special education services, even if a child is eligible, the school district may not initiate a due process hearing as a means of obtaining authority to place your child in special education. If you have any questions about your rights in regards to informed consent in special education, please feel free to give me a call.